Greetings, friends of liberty. I must say that if we survey the English system of criminal justice here in the 18th century, many of you would no doubt be shocked at its rigor. Truly, for one such as I, availing myself of Doctor Who's TARDIS, I can only marvel at the mildness of your penalties. Here, however, in the late 18th century, over 200 crimes may be punished by hanging. Among them, stabbings, burglaries, blackmail, embezzlement, any forgery of documents or coinage, any poaching or stealing of livestock, of course, and any smuggling. In addition, most cases are decided in under 30 minutes, and that includes the jury recess. However, if we desire to examine the fairness of the criminal justice system in late 20th century America, this book, at only 148 pages, by William Wilbanks, his The Myth of a Racist Criminal Justice System, published in 1987, excels. Given that racism has declined even further in the U.S. since then, this book has lost little of its value, and seeing the large number of politically correct books on the subject remains a vital resource. Wilbanks, a former criminologist at Florida International University, also wrote True Heroines, Police Women Killed in the Line of Duty Throughout the United States, 1916 to 1999, and Murder in Miami. Our criminologist divides his treatment into 9 chapters. The first, introductory. The second, definitional. The third, discussing why blacks and whites tend to disagree on the question. The fourth, on how hard it is to prove systemic criminal justice bias. Chapters 5, 6, 7, and 8 examining the question itself, and a final 9th chapter of conclusions. Given the huge amount of information and detailed arguments presented, as well as the statistical studies the author reviews, I'll only be able to cover some of the important substantive issues. Let's start our review with his second chapter on racism. He believing it's important to define, since many participants in the debate even today hold differing views. Prejudice is defined commonsensically as an adverse judgment or opinion formed beforehand or without knowledge or examination of the facts, or irrational suspicion or hatred of a particular group. Racism would simply be prejudice with regard to race, and discrimination would be an action taken by a prejudiced person. It can, of course, be both positive, favoring a person of a certain race, or negative. He notes also the frequent double standard that racism is often only used to apply to whites, giving us numerous different cases on television in court trials and training videos. Additionally, simple racial disparities are frequently judged to be racist, which of course today is the standard operating procedure of Kendi, D'Angelo, and company. He then presents a number of differing perspectives of whites and blacks about racial matters so that we can see how the two ethnic groups tend to differ. Number one, blacks, on top of having experienced significant real criminal justice racism in the past, are often surrounded by liberals who echo this view today. He says, there was a time when white society would not let a black leader emerge who expressed liberal opinions. Today, however, the situation has been reversed in that most black leaders attempt to stifle any dissenter to their liberal views. We all know, of course, how black conservatives are often regarded as race traitors, with Ayanna Pressley in 2019 saying, "We don't need any more black faces that don't want to be a black voice." Such racist attitudes are common among liberals. Witness the treatment of attorney Larry Elder when he campaigned for governor of California in 2021, the constant disparaging of Supreme Court Justice Clarence Thomas, and further back, Representative Hakeem Jeffries labeling then Secretary of State Colin Powell as a House Negro. Number two, one study reports that 1 in every 4 adult blacks in Detroit claim to have been stopped and questioned by the police without good reason. Blacks then, in this and other instances, may conclude that they're being hassled because of their race. Number 3, he believes that blacks overestimate the extent of overt racial prejudice in the white population. Number 4, some blacks can, on their side, believe that whites are reluctant to face up to current discrimination, since to admit that it existed would require that an effort be made to eradicate it. And number 5, blacks can believe that since whites predominate among those who work in the criminal justice system, the white citizenry identifies with whites who work in the system. And what do whites, on their side, tend to believe? Number 1, more or less, that white on black racism has disappeared. Number 2, that single cases involving obviously unjustified behavior by whites against blacks are viewed by black citizens as being typical, whereas whites view those cases as being atypical. Number 3, that blacks as being prone to interpret all behavior by whites as a result of racism. Number 4, that whites tend to interpret the black claim of a racist system as a political ploy to place white society in the criminal justice system on the defensive and to divert attention from the behavior of the black defendant. Number 5, that whites tend to perceive the level of criminality by blacks to be far higher than that for whites. And finally, number 6, they see blacks as being discriminated for through affirmative action programs and quotas. So now that Wilbanks has given us the tendencies of both whites and blacks to view things differently, in Chapter 4, he turns to an analysis of hundreds of studies, prefacing this by saying, the public is likely to think that we can simply research the issue and prove one side or the other. But many pitfalls are encountered in the attempt to prove whether discrimination exists at a particular point in the criminal justice system. So, for example, number 1, he gives the hypothetical example of a white judge who, being racist against blacks, gives black criminals reduced sentences for their crimes against black victims. Should this be scored anti-black or pro-black? Number 2, there are many cases where studies will conclude that a racist effect exists without having control for all the relevant factors. These include prior record, type of murder, type of attorney, whether public defender or private, relationship of victim to offender, race of offender and victim, socioeconomic status of offender, characteristics of judge, whether conservative or liberal, black, white, male, female, and characteristics of the jurisdiction, for example, urban or rural. Once these factors were controlled for, then, in many cases, the apparent racial differences vanished. Number 3, and why do so many studies not properly control for other effects? Because, as he says, data is not available. For example, few studies of sentencing control for prior record, though this is the most obvious factor one would want to control. Number 4, a large study can be statistically significant, but of limited practical value and significance because the strength of the relationship is so weak compared to the huge database. So, for example, studies of California with 180,000 cases and Pennsylvania with 60,000 can show small, potentially racist differences of 1 to 2%, which will crop up and be statistically significant without having any real predictive meaning. Number 5, what can also happen sometimes is a canceling out of effects. So as he says, Gibson examined 1,219 felony sentences handed down from 1968 to 1970 by 11 judges in Atlanta, Georgia. Though he found no evidence of racial discrimination in the aggregate, he did find considerable variations in sentences for blacks and whites among the different judges. Blacks were victims of discrimination by some judges, but the beneficiaries of discrimination by others. So now, having cleared away these frequently encountered difficulties of interpretation, let's proceed to Chapter 5 to see whether we can find actual discrimination in the first part of this system, the police. There are 4 basic complaints against them. Number 1, police over-patrol black communities. Number 2, the rates of arrest of blacks are prompted by police racism rather than actual rates of black offending. Number 3, that officers use more brutality when dealing with blacks. And number 4, that officers use more deadly force. So regarding number 1, over-patrolling. As Wilbanks says, the black community would be the first to complain about any redeployment of officers from a focus on street criminals to white-collar criminals. The black community wants more police protection from street criminals, not less. Let them go to a neighborhood crime watch meeting in the black community and suggest that the police redeploy away from the ghetto and into corporate offices. Regarding number 2, rates of arrest. As he says, the ratio of the black arrest rate to the white rate for the 8 index crimes in the FBI's Uniform Crime Report, murder, rape, robbery, aggravated assault, burglary, larceny, auto theft, and arson, was 4.51 to 1. So the first major argument for why this 4.5 to 1 ratio is objective is number 1, because this is approximately the same racial percentages one gets from the self-reports of victims. And number 2, when police have more discretion in charging for crimes, like with property crimes, where there are fewer eyewitnesses to identify the criminal, racial discrepancies go down, not up. So in other words, when the police have more control and discretion over who to identify and blame, racial disparities in arrests go down, which wouldn't happen if the police were racist. Regarding number 3, officers potentially using more brutality against blacks. So the first point to make is obviously that there are numerous reasons other than race why police might be brutal. Number 1, they may be unstable emotionally or not like the person's attitude. Number 2, they might feel they can't retreat from a commitment to arrest someone. Number 3, there may be ethnic differences of understanding and interpreting the words and actions of the 2 parties. Number 4, the arrestees may want to show friends how tough they are. And number 5, the officers, as recently happened in Memphis, Tennessee, with their notorious Scorpion SWAT teams, might enjoy beating the hell out of someone. In this case, 5 black officers killing an innocent black man, Tyre Nichols, in January of 2023. In summary, the unfortunate reality, however, as he says, is that data for beatings are simply not available, and such data not likely to become available. As Wilbanks says, I know of no empirical study of the complaint process for police brutality that has found evidence of racial discrimination. Perhaps that lack of data has been remedied by 2023. Finally, the fourth question on policing. Do officers use more deadly force against blacks? First, at this point in 1985, 60% of police killings involved blacks, who were only 12% of the population. Did that disparity indicate racism? First, at this point in time, though blacks across the country represent 60% of all victims of police killings, it is also true that 73% of all homicides by civilians are by blacks, 66% of all homicide arrests are of blacks, and 71% of all robbery arrests are of blacks. So these numbers would seem to indicate an approximate parallel with the 60% police killings. Secondly, police killings vary enormously by municipality. Since, for example, the justifiable homicide rate in over 50 cities ranges from 0.08 for Sacramento to 2.13 for New Orleans, indicating that a citizen in New Orleans was 27 times as likely to be killed by the police as a citizen in Sacramento. Thirdly, some data indicate no difference in killings by white or black officers. So, for example, one study in New York City initially found much higher rates of killings by black and Hispanic officers than white officers, but then found that for black officers, when they controlled for their assignment to black precincts and the greater frequency of off-duty killings involving black officers who more often resided in high-crime areas, the disparity vanished. So no difference between white or black cops in killings. Having examined the police treatment of blacks, let's next examine whether prosecutors, who have an enormous amount of discretion, are biased. Anyone who's read the news recently would know, of course, of the famous cases of extreme bias by New York District Attorney Alvin Bragg, Los Angeles District Attorney George Gascon, of San Francisco DA Chesa Boudin, the last two supported by that liberal mischief maker George Soros. Are prosecutors then, who are largely white, biased against blacks? Essentially, 5 potential questions have been raised. Number 1, do prosecutors discriminate with regard to setting bail conditions? Answer, Wilbanks argues here that this is more a question of income, not race, since poor whites are statistically treated the same as poor blacks. Number 2, do prosecutors not defer prosecution as much and charge more serious crimes to blacks? Answer, Wilbanks mentions here the literature is almost unanimous in reporting that charges against blacks are more likely to be dismissed before indictment. The fact that blacks are actually more likely to have their cases dismissed before indictment is even interpreted by some as proof that blacks are often arrested on flimsy evidence. Secondly, 2 studies didn't define that prosecution was deferred. Number 3, do prosecutors not give as many plea deals to blacks? Answer, here, as Wilbanks says, unfortunately, research on race of defendant and plea bargaining has been almost non-existent. Number 4, do blacks have to rely on public defenders who are worse more? Answer, first, as Wilbanks says, in an unpublished study, I found that for all 1980 felony cases in Pennsylvania, blacks and whites were equally likely to be represented by a public defender, 48% for both races. Secondly, Wilbanks only found 11% more blacks convicted when they had public counsel, which still doesn't prove racism because it might be related to their being poorer. Number 5, do juries exclude blacks more? Answer, as Wilbanks says, the most commonly lodged charge of racial discrimination against prosecutors involves the exclusion of blacks from juries in cases involving black defendants and the subsequent verdicts of these all-white juries. Historically, there's no question that blacks have been underrepresented as jurors in American criminal courts. The problem here ultimately is that since both prosecutors and defense attorneys have the right to strike jurors from a jury pool, there is no way around this problem, except over time when jurors, presumably of both races, will become less discriminatory. So a classic case here would be the O.J. Simpson trial. Blacks at that time believed much more that O.J. was innocent, while whites in this case were more rational and understood he was guilty of a double murder. So what happened? O.J.'s all-star defense team chose 8 blacks, 2 Hispanics, 1 half Caucasian, and 1 Caucasian female for the jury, who, of course, let O.J. walk. Years later, blacks realized he was guilty as sin, but the damage from their racial solidarity had already been done. But there's no obvious solution to cases like this since, as Wilbanks says, it is unlikely that much public support could be generated for any type of quota system in juries. Moving to the next phase of the criminal justice system, we find sentencing addressed in Wilbanks' 7th chapter. He says, there are more empirical studies on discrimination at sentencing than at any other decision point in the criminal justice system. About 70 studies examining the impact of race of defendant or race of victim on sentencing had been published by 1985. Let's please briefly review some of his conclusions for this complicated and lengthy chapter. Number 1, racial discrimination in sentencing has declined over time. Number 2, the race of defendant does not have a consistent impact across crimes and jurisdictions. Number 3, the race of victim may be a better predictor of sentence than race of defendant. Number 4, the black-white variation in sentences is generally reduced to near zero when several legal variables are introduced as controls. Number 5, the race effect, even before controls, is not substantially significant in that the predictive power of race is quite low. And number 6, finally, there is no evidence that black judges are less likely than white judges to send blacks to prison or to give blacks lengthy sentences. So, having analyzed sentencing, the next and last phase of the criminal justice system concerns treatment of blacks in prisons, which he proceeds to discuss in Chapter 8. Some of his main points here are: number 1, historically, segregation was customary in northern and southern prisons, partly to curtail violence between blacks and whites. Number 2, after the Civil War, the penitentiary equivalent of Jim Crow laws was the leasing of black prisoners to private companies for convict labor. Not only was this profitable for state governments in the South, but the state went so far as to railroad innocent blacks just to get more prisoners to lease. As Wilbanks says, the reliance on the leasing of inmates was so complete that Florida, which became a state in 1845, did not have to build a major institution until 1913, and that only to house those who could not be leased: women, the elderly, the sick. Is the prison system still racist? He argues that it's not, for the following reasons. Number 1, some American prisons are characterized by what can only be called racial warfare between black and white, and in some states Hispanic inmates. This, along with the fact that most prisoners choose to have a cellmate of their own race, means that segregation in American prisons is not presently done for racial reasons. Number 2, the traditional discrimination thesis completely ignores the evidence of racial hostility by black inmates against white inmates. Some researchers believe that humanitarian reforms have led to the virtual takeover of prisons by cohesive groups of inmates, largely blacks, which have filled the power vacuum created by the elimination of authoritarian and largely white staff. Number 3, generally speaking, blacks are more aggressive against whites than whites against blacks in prisons. In fact, this happens so consistently that in one juvenile prison, black guards, making up about half of all the guards, actively intervened to help white youth being constantly victimized. Number 4, the question of whether blacks are discriminated against in being denied early parole is hard to determine, with some studies showing and others denying bias. As Wilbanks says, it is difficult to read these studies and conclude that there is substantial evidence of pervasive racial discrimination in the parole process. So to conclude, has Wilbanks succeeded in demonstrating that the criminal justice system in 1985 was not racist in any serious way? I think he has, through every phase. The only question really that remains unanswered, as I mentioned previously, and Wilbanks himself notes, is how much sometimes pro- or anti-black judges will cancel each other out, thus creating, in the aggregate, no racist effect when there is actually some positive and some negative bias in some cases. I'd give this book an A minus, given its transparent prose, comprehensive coverage, relatively short length, and excellent insights, along with a superb ability to explain and interpret what's relevant and why. While being confident that you all will stay on the right side of the law, I bid you well and remain the Scarlet Pimpernel.